In the participants list, we have quite a few people right
Okay.
now. I assume that you can all hear, and as far as the panelists are concerned, also see us. We don't hear you because during the first part of the presentations, you're all muted, but that will change during the event. We just want to make sure that we get everyone on the same page as refers to the content, the basic content of the regulation, and then open the floor for discussions later on. Orlando Baquero, Managing Director of Latin America Verein from Hamburg, will give a brief introduction. Orlando, the floor is yours.
Thank you very much. Yes, very welcome to our webinar, Requirement for Supply Chains Particularity in Brazil. Thank you for Veirano and Advanced Biden to be open to share their insights, their knowledge with all of us. I think this is a very important topic. As many of you already knows, the Latin American Business Association is an institution over 100 years old, promoting business relations between Latin America, the Caribbean, and Germany, and thus also to Europe. We support, we help, we inform, and most important, we put people together so they can share experiences, find ways of communicate, start trusting each other, and finding ways how a sustainable development in Latin America can be faced, how Germany can participate of this development, and how Latin American companies can enhance their participation also for trade and investments in Europe. The Supply Chain Act. As many of you know, supply chain has been in discussion for the last years. We had many disruptions. We have the pandemic, the COVID pandemic lasting 3 years, causing a lot of disruptions, problems. We have the blockage of the Suez Channel, making also supply chain to Europe especially very difficult. And we have a bit of change in consumer of what they are asking for and what they're looking. Obviously, politics had to react, and it started to see how this can be addressed. And it's for us all obvious that we have to look after human rights, that we have to look after the environment when we have a print in any of the countries we are active. And I think the meaning of the law cannot be surprised that everybody agreed on it. Now, how it really works, which burden is being set to the companies to comply to these rules and etc. is a different topic. And I think every company will have to do an assessment and see how it fares, and obviously look and see for advice, counseling, and how to do it best, because it doesn't help not to look at it. We have to be aware. And the first step you are already doing here, attending these kind of webinars, because that's the way that you understand better the rules and you get insights how to manage it the best way possible. But you are not here to listen to me, you're here to listen to the experts. And so, Alex, I give it back to you, and I wish you all a very interesting, fruitful discussion. And please, if you have any kind of questions, even before the open session started, please write it in the chat so that we can address it immediately. Thank you very much. And Alex, back to you.
Thank you very much, Orlando. I think you set the tone. We will enter into the first topic, which is a law already effective in Germany that establishes duties of diligence on part of both companies in Germany for the selection and monitoring of their suppliers down the supply chain, but also indirectly, of course, for example, Brazilian companies that are suppliers to them. My colleagues Danielle Walden and Andre Depping have published on this, have done considerable research, and most of all have gathered some practical experience already, just as many of you from the participants joining us on companies side probably have already. So Daniel and Andre will give you an overview over the German law, just to get everyone up to speed in case not everyone is so familiar with it yet, which somehow constructs the ground for a hopefully fruitful discussion for your questions and their answers later on. Daniel and Andre, go ahead, please.
Alex, thank you so much, and also very warm welcome from both of us, Andre Depping and me, Daniel Walden. We are working obviously at Van Byten, and especially working on the Supply Chain Due Diligence Act, and we brought you a little presentation, which I tried to show you right now. Just let me see that it works. Okay, you can see that. As you will discover, we will not be able to go through each of the slides, but the idea was to also give you some background information. So don't be afraid or do not worry if we do not go into every detail, because we only have 20 minutes for this overview. Okay, so it doesn't work, but now it should work. So the first part of my presentation has the aim to put the German Supply Chain Due Diligence Act into the broader context of ESG and all these soft law and hard law instruments, which we already can see in this area. And the most important piece of work in the ESG area, from my point of view, is the United Nations Agenda for Sustainable Development, which was resolved by the UN a couple of years ago, and which has the aim to proceed with economic progress, of course, but as you can see, in harmony with social justice and within the Earth's ecological limits. So basically, this is the idea to not overconsume the planet and its resources, but to do it within the range of resources we have here on this planet. And from this agenda, to make it more easy to understand what it says, the United Nations also developed 17 sustainable development goals. There's a mistake on the presentation. It's not social, but sustainable development goals. And you can see them here, and it's easier to understand what that means, sustainable development. And as you will discover quite quickly, these goals, or some of them at least, also translate into the area of the German Supply Chain Due Diligence Act, as we will see later on. For example, decent work or gender equality, and other things like clear water and reduced inequalities. So this is one of the basic instruments, but as I said, it's only soft law. That means that it's not binding, and especially not binding for companies. And there are other frameworks which I put down here, and most important are the UN Guiding Principles on Business and Human Rights, and also the OECD Guidelines for Multinational Enterprises, which were already resolved also more than 10 years ago in 2011. And these two instruments are really the basis or the foundation also for the German Act, but also for the European proposal for European directive in this area, as we will see later on. So basically, all the member states of the United Nations had the task to transpose the UNGPs into their national systems. And what Germany did was to enact an action plan on business and human rights in 2016. And the idea was to find out whether the companies would be willing to to include human rights due diligence into their proceedings on not on a binding level, but on their free will. But actually, that didn't happen, and so the legislator decided to resolve this act, which we now have in place. So that the draft came out in 2021, and later on it was also enacted. And there's another regulatory proposal here, which I mentioned before. It's the Corporate Sustainability Due Diligence Directive. And my colleague Rainer Bierwagen will tell you more about that later on. It's only in proposal yet and not yet final, but pretty sure that this piece of legislation will also come in a couple of years into binding law in the EU. So we have here, at least in Germany, a couple of other legal instruments which also play a quite important role in the ESG sector. And this you can also see in the chronological order. All began as sometimes or often here in Germany with supervision law and supervisory authorities trying to engage financial institutions to look into different issues which become more important, and one of these issues is of course ESG, and the supervisory authority said that basically ESG risk is not different to other risks which financial institutions have to face, and financial authorities or supervisory authorities try to push forward this issue more and more during these days. And we also have in German stock corporation law provision, which says that the supervisory board should introduce sustainability aspects in the remuneration of the executive board. Since also now more than a year, we also have provisions as regards ESG in the German Corporate Governance Code, which is only soft law, but still has a very important role for publicly listed stock corporations in Germany. And then, of course, again, we also have this proposal for the European directive, which could become more broad than the German Act, because German Act is only, so to say, concerned about human rights due diligence, and the EU, or at least the Commission, the EU Commission intends to have a broader approach, also with regard to the duties of the management board, for example, or with regard to climate change and to try to prevent the consequences of climate change. So basically, here you can see some excerpts of the corporate governance code, which is not very important, and another piece, and then in 1 minute I come to the Due Diligence Act, but one also very important issue here in Germany and also in Europe is the non-financial reporting, or as it will be called in future, the sustainability reporting. As you might know, we have already the non-financial reporting in place in Germany and all over Europe, but only for specific rather big companies. And we have amendments to that, and one is already in force, which is the taxonomy, which is also like a very important and very broad topic, which you could talk about for a couple of hours, which I don't do now. And more important, there's the Corporate Sustainability Reporting Directive, which came into effect at the beginning of this year, and which will enforce and broaden the sustainability reporting, and considerably more companies will be obliged to do such sustainability reporting. meaning like in Germany, I think we have today like 500 companies which have to do non-financial reporting, and in future it will be around 15,000 companies which have to do sustainability reporting, which also is the gives the need for the companies to have processes in place which enable them to do this sustainability reporting, and it does not do it for itself. But that was only a foreplay to tell you and to describe you that the German Due Diligence Act is not a solitaire, but it has a broader background in the ESG jungle, so to say. So basically, what does the German Act says, coming from the UN guiding principles, which are non-binding as an international instrument, to make this non-binding instrument binding by law. And therefore, we have a legal obligation for addressees to fulfill their responsibility with regard to human rights, and to implement the core elements of human rights due diligence obligations into their processes. So in the end, and this is one very important point, the German Due Diligence Act does not require the companies to succeed in their obligation to prevent any human rights risks, and it does also not come to a guarantee liability of the companies to prevent any human rights risk, but it rather says that the companies have a procedural obligation, which means they have to work on the issue and they have to try to improve the human rights situation within their own operations and, of course, within the supply chain. Okay, so a very brief overview. Who is concerned with that legal obligation? It's applicable only with regard to certain companies which are domiciled in Germany. So if you're a foreign company, you will be very probably not be a direct addressee of this piece of legislation. But this can be the case if you have a branch office here in Germany, or if you have a subsidiary in Germany, as we see on the next slide. And in any case, you have to have more than 3,000 employees working in Germany, or with the beginning of next year, this limit will be lowered to 1,000 employees. So if you are a group of companies, of course, it's not only relevant which each of the company, how many employees each of the company actually has, but it's relevant how many employees are working in the group. So I brought you a little example here in the base scenario, which you can see at more at the bottom of the page. You have a parent company in Germany, which has 100 employees and a couple of subsidiaries. And if you count the number of the employees, then you will see that the group has more than 1,000 employees, and then it's quite easy. The result is that this parent company will have to follow the German Act as of 1st of January 2024. So one of the many questions which are unsolved is what happens if this German parent company is not the ultimate parent company, but there's a parent company abroad. Does that exclude application of the German Act for the German parent company? That's still unsolved, and from a legal point of view, it's of course advisable to rather follow the law than to take the risk that you have to follow, but you don't comply, actually. Okay, So if you now say, okay, I'm not a company in Germany, and I also don't have a subsidiary in Germany or not so many employees, then it's fine for me. I'm not affected at all. Then that's not the right conclusion, because as the name says, it's a supply chain due diligence act, and of course the addressees of these regulations, they have to bring forward human rights issues into their supply chains. So as soon as you're a supplier of one of these addressees, then you will, of course, get into contact with the results of this German Supply Chain Due Diligence Act, because the addressees will try to force you to give certain contractual obligations, to enter into certain contractual obligations with regard to human rights. Andre will tell you more about that in a couple of minutes. So if you now say I'm not a direct supplier, but only an indirect supplier further behind in the supply chain, and I'm not affected, that's also not true, because as you will see later on, there's also some obligations which also stretch out in the further supply chain. That means not only tier 1, but also behind. Okay, so what is basically the area of protection, so to say? As I already mentioned, we are talking about human rights and also environmental risks, and the Act has certain prohibitions, which it says these are basic human rights which should not be violated, and companies have to take care of that. And these areas are listed here. It's like child labor, of course, and forced labor, occupational safety, unequal treatment, destruction of environment, unlawful violation of land rights, and so on. And you, as you will remember, as I showed you the 17 sustainability development goals, you can see that this translates into this act here. And also to mention is that these topics here, it's not a German invention or so to say, but they are all derived from international treaties and from treaties of the International Labour Organization. And as you can see at the bottom, there are also, in addition to the human rights, there are also 3 international conventions concerned with specific topics like mercury or hazardous waste. Okay, so as I said, the Act is concerned with the supply chain, and supply chain means in the meaning of this Act, not only the supply chain, but also the own business area. That means addressees have to also take care of their own business, even if they have subsidiaries abroad. That also is included into the own business area. Their direct supplier, meaning their contractual partners, and also the indirect suppliers. And I brought here another picture to make it more clear. If we have a producer in Germany with 3,000 employees, it's an addressee, and the raw material trader would be a direct supplier, and the raw material producer, the indirect supplier. And as you all know, reality is much more complex, and we are not talking about a supply chain in principle, but rather a supply network, because everything folds into each other's. Okay, so what has company to do is to have a risk management, and this is quite similar to other risk managements like compliance risk management or the traditional risk management, which requires a company to do the circle here. And I will not go into detail because time is running so fast. But if you're interested into that, on the next slide, you can see a quite similar process. And this process is taken from the OECD due diligence guidance, which I mentioned before. And as you can see, it's quite similar. So if you want to know more about the process and the human rights due diligence, then you could have a look into that document. It's also in English and not only German, but by the way, you can also find a translation of this German act in the internet. Okay, so risk analysts, perhaps we can dive into that later on in the discussion. And last two sentences which I want to mention is that, of course, it's important to comply with the German Act. So it's not anymore the question whether it's good or not good, so to say, but for the addressees, it's just a question of compliance. And if you're not compliant, then you will face administrative fines. And for some companies, also quite a sanction is that you could be excluded from the award of public contracts. So this is basically what I have to say to you in a couple of minutes only, and I'm happy to discuss with you further in the next steps of our webinar. And now I'm handing over to Andre.
Just briefly, Daniel, there has been a question from Nicolas from the audience. I think you answered it. Just want to make sure before we pass over to the next chapter. The question was, does the German law on diligence and supply chains apply to a foreign subsidiary of a German company operating exclusively in another country? And
yes.
I think you've confirmed that. And just
yes.
to be
if it's a subsidiary of an addressee, then it's yes. So if you're a big company in Germany, like for example Volkswagen, you have a subsidiary in China, and this subsidiary in China is also included in your own business operations, in your own business area, and so it's part of the supply chain within the meaning of the Act.
Yes. Same if you're producing wind parks or
sure, it doesn't depend on the industry. It's yes. Always the same.
Perfect. Thank you very much. Andre.
You're welcome.
Okay, hi everybody, also from my side. I would like to give a brief overview of how prevention measures are established in the supply chain, because here it gets directly relevant for the suppliers, also for the Brazilian suppliers. Next. Let's take a look at the graphic again. Daniel has shown so that we know where we are. Preventive measures should follow the risk analysis and the definition of the human rights strategy. Next. And now let's take a look of what the Act requires in terms of preventive measures towards direct suppliers. So we can read it together. The company must integrate appropriate prevention measures towards a direct supplier, in particular, the consideration of human rights and environment-related expectations when selecting a direct supplier. 2, the contractual assurance of a direct supplier that this direct supplier will comply with the human rights and environment-related requirements requested by the management of the company and will address them appropriately along the supply chain. And 3rd, the agreement of appropriate contractual control mechanisms, as well as the implementation of training courses and further education for the enforcement of the contractual assurances of the direct supplier pursuant to number 2. For it's not so relevant here. So next. This is therefore the first step, a matter of contractual regulations vis-à-vis suppliers. In principle, it is possible to negotiate the necessary regulations individually with each supplier. This would best comply with the Act, as prevention should tailor to the identified risk. In practice, however, this is not feasible if you have numerous direct suppliers. In practice, the necessary provisions are therefore either integrated into general terms and conditions, or reference is made in the contract to a supplier's code of conduct. In both cases, they are legally general terms and conditions, which under German law are subject to a certain level of content review, even in B2B transactions. Next. The individual human rights and environmental requirements that are important must be clear from these contract clauses. Daniel has already said something about these requirements, so we go to the next slide. Because beyond that, however, there are other issues to be addressed. The first is to agree on appropriate risk-based control mechanisms that can be exercised once a year or on an as-needed basis. In practice, auditing rights are agreed for this purpose. It is not at all easy to formulate an effective clause here. As a rule, advance notice is required. The purpose must be clear, data protection must be taken into account, and so on and so on. Next is a duty to transfer the obligation in the further supply chain. Daniel just said it. Here too, it is not easy to formulate a valid clause. If one obligates the supplier to obligate its suppliers, the clause is likely to be invalid. Depending on the market power, it may even violate antitrust law. The only way to be on the safe legal side here is with an obligation to make an effort to pass on the rules to the further suppliers. Remedial action against direct suppliers should also be specified in the contractual clauses. It should be made clear that a violation must be terminated immediately and that the supplier must submit a concept or a schedule if it is not possible in short term. The possibility of terminating the business relationship should also be regulated, but only as ultima ratio. A regulation on the complaint procedure should also be provided in the sense that the supplier must inform its employees and subcontractors of the possibility of a complaint, even with providing contact details. Next. So in summary, a company that is obligated under the Act faces serious challenges in implementing the preventive measures. It must use effective but also legally permissible clauses vis-à-vis its suppliers. It must bring about a corresponding contractual amendment to existing supply contracts with each individual supplier. It must try to penetrate the entire supply chain without having any real effective instrument to do so. It must create a fairly comprehensive set of regulations, which experience has shown initially causes a certain resistance on the part of the suppliers, since the scope is difficult to oversee. And last but not least, it must continuously provide a high level of control in order to be able to credibly document the fulfillment of the duty of care. Okay, so let's have a discussion. Thank you.
Well, thank you, André. I think from your deliberations, it becomes very clear that this doesn't only impact the German parties in any sort of contractual relationship with their suppliers abroad, in our example, Brazilian suppliers, but also the latter. When they're being faced with audit right provisions, everything you just mentioned, the control mechanisms, and when the parties contracting them as suppliers are increasingly under pressure. Actually, a parallel can be seen to other areas of law, such as the area of compliance, where we've seen quite a few pieces of legislation in several countries with territorial reach as well, and where multinationals over time have put companies also in developing countries, BRICS countries, Brazil particularly, under a lot of pressure, and have provoked that in the local reality, many things have changed. So I think it's worthwhile to look into the reflexes that this legislation has here in Brazil. I think my partner Maria Cristina has also joined us. Maria Cristina, you're specialized on ESG. Maybe you present yourself briefly and give us a first input on this.
Hi, good morning.
Hello.
Hello, can you hear? Just testing. Okay, good. Hi, it's a pleasure to be here today. I was hearing very attentive the lectures, the presentations before, and I think there is from everything that we are analyzing here, for me, it's very clear that it will be necessary collaboration between Germany and Brazil and the companies in order to be able to comply with such law. Under a Brazilian perspective, Brazilian companies are, of course, they are worried on what? On how all these requirements from the German Act is going to affect their contracts. And I think there are some middle grounds that are very good to know that we have in common. Brazil, such as Germany, is a signatory of several international instruments and treaties on protection of human rights and environment. And from what I learned from the previous presentation, Germany, it's very much based on the UN considerations and principles in order to put in place in practical terms what the German Act is requiring. Brazil as well has an SG pressuring agenda in relation to surveillance bodies. For example, our central bank as well has a list on taxonomy, has also enacted acts in which financial institutions are also required to assess environmental and social risks, how this is going to affect their risk assessment under reputational, operational, and creditor terms. So I think in general terms, the word in a certain extent, especially here that we are talking about Brazil and Germany, it's a kind of aligned. What we see here, it's the questions that we have, and the concern is how this is going to be implemented on practical terms, because as it was mentioned before, we are moving from a period of voluntary requirements, and now there are requirements that are provided on the German Act. And how German companies are going to require suppliers in Brazil to demonstrate that they are actually complying with the requirements that are being requested by German consumers and German companies that have to abide to such law. I think one aspect that's very important is about how this is going to be addressed on the contracts. And if it's for under Brazilian perspective, and here the suppliers something I think for German companies to think, is it going to have a transition period, for example, to comply with such rules? Because in practical terms, it's going to be necessary, you know, for the companies here in Brazil to incorporate the requirements, because the game is already playing, and to change the rules of the games in the middle, that will be necessary to have a collaboration of the parties that sign such agreement. And something that also caught our attention, and when we read the German Act, although I'm not an expert on German legislation, is that we are moving to a period not only of declaration and intention, we need to have evidence on that. And if we have evidence, how we are going to act upon such evidence. And this is something that I would like to bring from my experience in other projects, basically in which our clients had to observe equator principles, or when we had investors in Europe that were signatories of some ESG agreement. It's the necessity to understand local rules as well. Brazil is a country that has several environmental and human rights rules, labor rules, inclusion on the employment, resting periods. I mean, there are a lot of aspects in our legislation. And as you know, Brazil is a very rich country on natural resources. So a lot of projects, they're close to conservation units, protected areas, but this is a peculiarity of Brazil, because we're a country that we have, everything has the good side and I would say the bad side, because very good that we are a country like this, because we have a potential to provide green service as well. You know, when you're looking to the supply chain, we are a clean energy country, and this might add value on the risk assessment for the German companies. But on the other aspect, we face issues that are not common in Europe. We have indigenous communities here, for example, and in our opinion, it's very important when the risk assessment is made by German companies that they can understand when they find something that seems material in their risk analysis, what's going to be the conclusion? For example, to have an infraction notice issued by an authority in Brazil on claiming that there was a non-compliance with environmental rule doesn't mean that actually it happened. There is the due legal process here. This company might be disputing this, and how German companies are going to analyze that. Another specification, I saw that there is specific wording on contaminated areas. When you read the German Act, there are a lot of companies like in Brazil, in the US, in Europe, that they are operating in contaminated sites, but they are promoting the remediation measures under the surveillance of the environmental entity here in Brazil. So I think in practical terms, we might face in some cases situation like this, and I think that lawyers in this case might are going to be very helpful, because from German side, you can tell what's material, what's the concern under a German perspective. And then on our side, we can bring this analysis on the qualification and materiality of such risk. But as Daniel and Andrea said, in the end of the day, this is a risk management rule, taking into account human rights and an environment. So the company in German is going to define based on sector, based on the activities, based on other aspects, might have other, I would say, voluntary compromises that they have assumed, and they are going to analyze their business under this human rights and environmental perspective, taking into account what the legislation provides, what is the voluntary compromise, and how they're going to transfer this to companies here in Brazil when they are the suppliers. Reporting for us is another issue of concern, how German companies expect information to be reported. And something else is that there is this agenda in Europe on climate change. In Brazil, there is as well, but we have a different agenda. So how much of climate questions are going and the requirements are going to be, like put in place in Brazilian companies, considering that in many cases, we are not discussing, for example, scope 2 or 3 of climate change, of climate emission reduction. So I'm just giving some examples, looking very much into a practical point of view and thinking about bridges that we can construct on how we can make this process, the most effective, and also with upsides, I think, from both sides, to make it's less costful, but at the same time appropriate, to provide the evidence that the German companies need, but without, like inputting a lot of costs also to Brazilian companies in the context that they will have to adapt themselves, to be competitive and still be able to maintain such agreements, commercial agreements with German companies that are buyers of our service and goods here in Brazil.
Thank you very much, Kika. I think it became obvious that for one, all practical issues in terms of reporting, diligence, need to be evaluated between the two countries when we have contracts between parties in both. And that also here in Brazil, we will probably, even though it's a work in progress, be able to give back some sort of information as to how the actual situation is here. And there are several examples that Maria Cristina has mentioned. If you look at the issues that are being treated in the German law, those also include child labor and labor in slave-like conditions. We have a huge discussion right now, especially as refers to companies down south here in Brazil, where we've seen several cases, unfortunately, of slavery-like working conditions. Among those and the environmental issues, I guess there's already a lot of room for specific discussion later on in our more interactive session with participants. But maybe to briefly cover content-wise also the European perspective. And the European Union has been very active on the sustainability front. Maybe Rainer Bierwagen from Advent Byton can fill us in on the basics. Rainer.
Hello, do you hear me?
Yes.
Okay. Well, let me talk very briefly about that. I regret that my camera doesn't work today as I'm in a different office, but I'm not Arnold Schwarzenegger. You would see an old man, so that doesn't deprive you of anything important. There are a few points which I would like to put to you. An appeal from an international law perspective, an appeal from a personal perspective. We all want that the world which we leave to our children is not a worse world, a worse environment. That is one thing, and there, for what the EU is doing and what the German government, German parliament is doing is something which I strongly believe is very good. Also, you have to see that other countries will follow suit. You remember the discussion about the REACH, the chemical legislation. More than 10 years ago, there was this strong discussion, strong reservations about the EU approach of looking at the dangers of certain chemicals in the production of other goods. And what do we see now? Everybody is copying the EU legislation. And the most important aspect for you and your companies is, if you do it now, you will have an advantage over other countries, and at any rate, it will also come to you. I'm sure maybe in 10 years' time, you'll do the same thing. Now, very briefly, EU 27 and national law. Where it is applicable, the EU law takes precedence over the national laws of the 27 countries. And right now you see that our 27 countries have different agendas. We have a legislation in Germany, we have something in the Netherlands, and starting legislation in the other EU countries. Once we have the EU directive, the countries are forced to implement the directive in national law, not not sentence by sentence, but the purpose of it. So when you look today at the German legislation, later on, you will have a very similar legislation in the EU. Next slide, yeah. In that slide, you also see Fit for 55. Fit for 55 is not that you become fit when you are 55, you are looking all much younger. It is fit for the reduction of emissions over the next couple of years. This is a very, how to say, an objective which we unfortunately will probably miss, but we have to go there. The future of mankind, the future of humanity depends on us reducing our footprint, our negative footprint on the environment. I know that this requires changes, and this requires also changes to behavior in developed and in developing countries, and the question of who has the bigger burden and will there be a compensation. But I don't want to delve into that. What we have and what you concerns either as companies or as lawyers is who will be covered by the legislation. This, and if you go to the next slide, we have a commission proposal of last year, which says it is only very big companies, and if they are smaller, they are only in high impact sectors. So like agriculture, extraction of minerals, etc. And the same for non-EU countries. If we go to the next slide, you will see that the EU Parliament, which has a different proposal, is looking at increasing the number and scope of companies to be covered. We will, over the next couple of months, see whether the negotiations between the European Parliament, the European Commission, and the 27 member states united in the Council will arrive at something restrictive, more limited, or something more larger in scope as the European Parliament wants. My guess is that it will be more limited more in line with the Commission proposal. Now, if we go to the next slide, what will be there? We will have obligations which are basically in line with what you have in the German legislation. The European Union legislator doesn't reinvent the wheel compared to the German legislator. Of course, the wording will be different and some scope will be different, but we cannot talk about the details right now. There will be sanctions, and the question is, as already discussed here, is how will these sanctions be implemented? Do we have a reach outside of the EU? Probably not, but if a company has a footprint in the EU, we can impose sanctions. And the other thing is that we can shame the company and the supplier, and we can deprive them of selling in the EU. Finally, in the next slide, the only thing, this is what I just mentioned. We have three texts. We have the European Commission proposal, we have the Council proposal, Council is the EU member states, and we have the proposal from the European Parliament. This will be slashed out and over the next couple of months. Final remark is, this is not the only legislation which will concern you. I think we have to add another 2-3 webinars over the coming months, because there will be more rules with the Fit for 55 programs, and there are already rules in which we have in place, like the Corporate Sustainability Reporting Directive, which also has indirect consequences for you, because the German companies or the European companies will require information from you in order to do this reporting. So here finally you see an elder man. I'm here to report and to help you, but this is all what I have to say, and the specialists are André and Daniel, who are here to tell you or to answer your questions about the details which we already have in place in Germany, and which will be very similar in the EU 27. Thank you.
Well, thank you very much, Rainer. I believe after having had this, more theoretic introduction to the contents that are concerning us, maybe it's time to take a dive into what companies in Germany are facing based on that. I think someone who's in a privileged position to let us know about that, who has a good overview over what companies are doing as they're dealing with this legislation also in Latin America, is Orlando. Orlando, maybe before we get into the Brazilian side of the repercussions of European legislation, also that to be expected, you can give us a little bit of background information of what you hear from Latin America Fine members.
Yeah, thank you, Alex. I think it's quite important to make some big remarks. So the ley is applicable to all companies, as it was explained in the beginning, based in Germany or having subsidiary in Germany. There are some rules about the size, but this rule really doesn't apply in practical way, because if you are a small supplier of a big company, so you have to adhere to the rules too. So it is not negotiable rules. So you have to apply, you have to do it regardless of country-specific situations or regulations. So it doesn't matter if a country is a high-risk country or not, you have to apply. So there are two main aspects of the German law which have to be done. One is the risk assessment, and this is what companies are doing right now, or finishing, is the risk assessment. The risk assessment normally for companies, it was difficult because normally you look for risk which affects your business, financial risk, political risk, environmental risk, all this kind of risk. This is what you normally look as a company. And now you have to look for the risk you as a company can cause to your neighbors, society, environment, etc. So it's a different approach, but this is the first thing everybody is doing, and obviously asking their suppliers to do. So a risk assessment is something you have to have if you want to keep having business relations with German companies. And the other one, which is very important, is the mechanism to have control if your risk management system is working. That means you have to have a monitoring system. You have to have the way that people can inform you, and you have the way that react. This information management system you have to build that everybody can, in a way that is easy for everybody, report any irregularities, have to be in place. This is a bit more, probably a bit more expensive, more difficult, because when it's called everybody, you need also people who cannot read and write. You cannot use just a WhatsApp number. So you have to have a quite good system to inform irregularities against this act. And this is the two main points people are facing. Independently of what is really the situation of the countries, you have to have them in place. And so if you are aware what your risk is, and you have monitored it, and you have measures to improve the situation, then you are on the good side. But these two parts have to be done immediately. And this is what companies are right now doing. So a full risk evaluation system, and the monitoring system and reporting system afterwards. And this is regardless of the situation in the country. If we compare, obviously the company members here make businesses with all continents. If you see, Latin America has not that much issues as other parts of the world. But nevertheless, we have to have the monitoring risk system, even for doing business within Germany. So it's not only for international trade, also for the supply chain within the European Union, you have to have it in place. So these both points of the law are what people are focusing in. And I think this is the backbone of this, and this will help you obviously afterwards for the European regulation. These two places will be there in any case. And I think this is the most important thing that we have to tell the companies, that start preparing the risk evaluation and the monitoring system.
That's certainly very relevant. I just asked our marketing to open the microphone function also for everyone participating, because I think before we move into the next panel discussion about foreseeable consequences of the EU legislation on companies here in Brazil in more detail, maybe you can, whoever wants to, add to what Orlando just said, and maybe tell us a little bit about where you stand as companies, what your concerns are as refers to complying with this legislation. Is there any voluntary among you? Maybe not right now. If you have questions or comments, I'd kindly ask you to raise your hand so that we can fit you into the rest of the program. On the basis of what we just heard from Rainer about European legislation, There are different pieces of legislation, some already in place. We're looking at CBAN, we're looking at the Sustainability Directive, the Deforestation Directive, and all of them have impacts on the region, in our case on Brazil. One of the large sectors here in Brazil is the real estate sector, and probably one of the biggest, which accounts for about 1/3 of our GDP, is the agricultural sector. If we look at potential impacts that, for example, the Deforestation Directive has on the real estate sector for rural properties nationally here in Brazil, and indirectly, if you look at impacts on, for example, joint ventures of foreign investors with Brazilians acquiring land here in Brazil, that is certainly an area where we expect a lot of movement as a result of this legislation. We have with us here Gabriel Abadji, my colleague from our real estate team. Our partner Gisela unfortunately had to go into a client's meeting, an unexpected one, so Gabriel is taking her place. Gabriel, maybe you can briefly introduce yourself and give us your thoughts on how European legislation might affect local reality here in Brazil in the real estate sector.
Yes, of course. Good afternoon, everyone. My name is Gabriel. I'm an associate of Verano Advogados in the real estate practice area, and also a member of our German-speaking desk. And as Alex already anticipated, I think there might be some relevant impact in the real estate market in Brazil. Because from my perspective, when I think about the relationship between our countries until now, everything was regulated on a contract. So there were representations and warranties on the side of the, well, on the side of the Brazilian supplier, where it simply stated, or the company declared, that it was complying with all applicable regulations and legislation, that it did not infringe any environmental related or human rights related legislation. And that was basically it. There was no system in place that really dictated for the company in Germany to be doing these checkups on their commercial partners. And it was perhaps a comfortable position for the companies in Brazil. Perhaps there was a situation at the time of signing of the commercial agreement, and they have a commercial relationship that went over, I don't know how many years. And throughout those years, something came up that the German company was not checking into. It was not affecting the commercial relation with Germany. But upon the enactment of this new law, it is certainly something that is going to affect this relationship. And here I see, and that's just a hypothesis, of course, maybe a risk the Brazilian companies will now have to think if they still want to operate in certain real properties. As Maria Cristina, our colleague from the environmental team, has already anticipated, there are some properties in Brazil which are contaminated, and the operations are being carried out there. And the company has in Brazil some remediation procedures in place. Maybe the damage, it wasn't even caused by the company itself, because in Brazil we have a property hand obligation to remedy those damages. So maybe it was a damage caused by the predecessor and the current owner of the property is dealing with it. But in light or in sight of this new legislation in company, we might see a movement in the market to kind of try to distance himself or itself from those kind of real properties, from those kind of liabilities. So people will say, okay, I'm going to put this real property in the market because I don't want to have this stand on my business, on my business operation. I don't want it that it somehow compromises my relationship with partner companies in Germany. And as a result of that, we might see depreciation in the value of some real properties in Brazil. That's one aspect that I wanted to bring to you guys. And another aspect, maybe a provocation, Maria Cristina also mentioned how costly this process might be. And there may be, it's just a hypothesis. We'll have to see how the market reacts. But there may be some business people in Brazil who are afraid and uncertain about the real consequences of this legislation in Germany. And they think, okay, it's getting too complex for me. I don't know to what risk I'm really exposed here. We have penalties in Germany that can go up to 8 million euros. And contractually, I'm sure the German companies will want to pass this fine along to the suppliers when they are responsible directly for the fine. So what we call in Germany, die Bußgeldabwälzung. So maybe the companies will say, okay, that is too risky for me. I don't want to or I want to perhaps redirect and reroute my operation to another country. Maybe I want to export more to China, where such requirements are not present. So that's maybe a reaction that we may see in the market. I don't know how many persons will do that, or how substantive the reaction would be, but I wouldn't disregard or discard the possibility. And there's a last aspect that I wanted to bring to our conversation is about the nature of the Brazilian real estate registry system. We have a registry system in Brazil that is quite detailed and exhaustive. So when you look at a retrofile certificate of the property, it's practically not only a birth certificate, but more of a life certificate of the real property. You can see that the most relevant events and data and information related to the property. So if there has been a judicial proceeding related to perhaps an infringement of environmental legislation, there might be annotated on the retrofile certificate to make this information known to the public. And that's something that German companies can take advantage of in this new context of the law. Because when we are talking about direct investments in Brazil, like a purchase or lease of rural or of any real estate in Brazil, we normally do a thorough due diligence. On this now new context of commercial relationship between Brazil and Germany, German companies may be interested into looking and doing a thorough analysis of their partners in Brazil, and our registry system is certainly a valuable institution within our country to provide such information. I think, Alex, from my side here, those were the points that I wanted to bring for first talk, and I remain available for the questions.
Thank you, Gabriel. I guess it becomes obvious that we're dealing with a very multifaceted issue and legislation and consequences of that we're dealing with and our clients are dealing with. As we said before, the agricultural sector is being affected quite severely, especially by the deforestation directive. We have here with us my partner, Luis Felipe Andrade, who's leading our sector practice for agricultural business. Luis Felipe, maybe you can fill us in on what you're perceiving so far and what you're expecting for the future based on what Rainer just said. Go ahead, please. Please introduce yourself.
Sure. Can you hear me, Alex, and everyone else? Yes, good. So thank you for inviting me here. Big responsibility. All the presentations were pretty good. Gabriel just gave a wonderful overview of how these legislations may affect the real estate sector. I am here more involved in the EUDR, the deforestation rule, in the analysis of it and its impacts in Brazil. I have also looked a little bit on the other directives and the proposal of the sustainability directive. I think that Orlando gave some hints about what's happening in the risk assessment works that are going on, and this is also part of the EUDR as far as I have analyzed. So it is an important aspect that should begin to be implemented here by all companies in the agribusiness sector that have some sort of relationship with Europe. So I think risk assessment is a first and critical point. I would say even the first one is having sessions like this for people to know a little bit more about these topics and delve into the details and understand what will be the requirements. And obviously, the risk assessment being one of them under all these compliance measures that the EU will impose in the many different sectors. So for our agribusiness in particular, because of the EUDR, there is already a lot of discussion in Brazil. There has been also many initiatives from particular subsectors of agribusiness and associations to try to influence the EUDR. What I've heard is that most of our initiatives failed, and there was a lot of deaf ears in Europe and a lot of not exactly Europe is not exactly into the problems of others, but out looking into setting up the standards from within and then to the outside world. We will have a phase, I believe, that there will be a risk category attribution to countries. And this is something that we know that Brazil is looking at and intends to negotiate as well. We just had Ursula von der Leyen this week here, and I didn't see any news about the EUDR. I've seen some news about Mercosur agreement, but because all of these initiatives are pretty much interconnected, there may have been some developments, but before that, what I've heard basically was that Brazil was on a more advocacy level concerned because to this point there weren't many openings to discuss the matter, and of course it's hard to actually go to the EU and say, well, you need to listen to us because there are so many other countries that the EU will likely have to listen as well. So I'm pretty sure the diplomatic effort here is very complex. In terms of, let's say, the two avenues here that I think Brazil should be looking at all these initiatives. First, strictly from a private sector standpoint, although there are some legal issues or even some requirements that may be too harsh, overall, I think that the initiatives towards controlling your supply chain from an ESG standpoint, from an environmental or social human rights standpoint, I think it's something that's coming here to stay. It's not just about Europe. We have these here as well. Maria Cristina has mentioned about our central bank initiatives, for example. So this is not something that we're just going to close our borders and say, well, no, we are not going to sell to you. We're not going to adapt. We're not going to adjust. I think we probably will. And there have been many other past initiatives that resulted in countries moving forward. So the Industrial Revolution started with so many issues, and then we as a species, humans, started imposing controls, and the industrial activities became healthier for workers and so on and so forth. So this is part of, I would say this is part of an evolution. Regarding agribusiness specifically, there is a lot of focus on the EUDR now because, of course, there's a shorter time frame to start complying. It is a regulation, and here our German friends can correct or compliment me, but it is a regulation that will be basically immediately enforceable. Each state will not have too much difference in terms of what they will adjust for checking compliance. It will be an immediate applicable regulation. We are seeing lots of movements in Brazil to confirm traceability of the commodities that we sell, which are, of course, our main concern now. We have a few or most of them that we lead or are among the three biggest exporters are there in the EUDR, which has even led to some feeling that the EUDR was targeting us. And I don't know if this is paranoia, but obviously we are concerned about the impact that's going to have on these particular commodities. Our chains are, of course, not without traceability problems. Some of them have more or less control. For example, soybeans have had a soybean moratorium for acquisition of soybeans from the Amazon region for about 15 years now. What concerns us in that particular sector is obviously whether the current control that we make would be acceptable, or the kind of tools that we have would be acceptable. There are still problems also in commingling grains in storage and shipping systems. So there is some way to go, even in a very sophisticated chain such as soybeans, for example. We have also beef being affected. This is we still have some issues as well that we need to work on, although it's clearly improving as well. Obviously, in this particular sector, we sell a lot to China and Asia, and there have been some conversations that, well, okay, so we will just divert everything to Asia. I'm not sure that's going to be possible or even interesting. Whenever you shut down a market, you're not going to get an increased price. You're going to get probably a lower price, even in the case of commodities, which is something internationally regulated price-wise. So I think that for us in Brazil, these initiatives, we need to look at them as a trend, of course, not give ground on things that we believe are absurd, but try to work as closely as possible and cooperate to bring a little bit more of our reality in these discussions. Brazil is just about the size of Western Europe, so we are not exactly the same everywhere. Regionalization, for example, is something that we have been discussing to bring to the EU in terms of the risk classification of the country. So I think bringing our reality is what we can do. There's obviously the risk of a trade dispute as well. We will need to demonstrate loss. This will take a long time, but it's not off the table as far as I heard. And there are quite interesting arguments actually to try to cut some pieces of this legislation that are not exactly fair. There are some pieces that I believe personally are that they can stand there, are good, and will be positive in the future, but maybe some other details will need to be adjusted. So here from a Brazilian agribusiness standpoint, I think the word of action is traceability. We need to work as much as we can to trace all of our commodities, all of our products as best as we can. We do have a legislation on our forestry protection legislation has been under let's say under a period of settling the disputes in the last decade or so. So I think it would be interesting for Europe to try to understand that as well. It has been a contentious issue for many years. And then we had a new forestry code in 2012. We've been settling this situation. There are some issues. As I said, Brazil is very large. All regions are quite different. And we do have, from my point of view, some homework to be done in terms of our documentation, of our geolocalization of our properties, of making all of our legal reserves, the percentages that we have to comply in Brazil, properly documented and registered. There's still some way to go there, but we do have strong forestry instruments, probably more restrictive even than many countries of the world, that we are trying to implement. Another issue that concerns me, particularly in the agribusiness standpoint, is related to, we do have a broad concern about what's going to be needed to prove compliance with human rights, or in agribusiness, to me in particular, indigenous people's rights, which is something that is extremely contentious here as well. And that has been the topic even of a Supreme Court discussion this week. So that's a topic that concerns me in particular. The level of documentation, the level of compliance, how do we demonstrate that in our chains in Europe? I think that still will be probably refined by the EU. There are some initial indications there in the risk assessment, in the mitigation measures, but obviously we need to, I think that from our side, we need to work on our traceability, work on our documentation controls, demonstrate that we are strong about these aspects in order to play this game, and not necessarily just to fight on something that's going to sound very bad reputational wise to the world. But as I said, I do have my own criticism of these of how these things happen. I'm not sure I would have any other different alternatives, but also there are some particular aspects that I believe it would be good for Europe to hear all the other nations in order to work together, to collaborate and to incentivize, and not necessarily just to punish or cut off from the market and so on and so forth. Because obviously there will be winners and losers on both sides. So I'm pretty sure there are European interests that are looking at this also with these concerns from, you know, trading companies or many other companies that sell products to us down here. So overall, because agribusiness has been more involved and has the EUDR, I think that the current experience level that we're seeing in terms of the discussions and also the way we are moving in a private sector towards traceability, I think we are doing work to improve traceability, and we are not. So we are, I would say, improving our work there and our satisfaction level there. We are doing what we need to do and going hard. There are laggards, but there are also other companies that are moving forward very strongly about that. But from, let's say, a collaboration, a communication, or a discussion standpoint, there is a pretty high level of dissatisfaction with in particular the EUDR, the way it is being set up. Also because of the rule that will prohibit acquisition of products from legally deforested areas. But I think that we need to, Europe probably passed the phase of approving this and making all its population a little bit more satisfied about that. And we go into the details, and the devil will be in the details. And I believe that people will accommodate compliance and also understand a little bit more the conditions that all countries will present. So those are my comments. I think personally, overall, I think the initiatives are good. But of course, some of the details need to be ironed out, maybe a longer transition period, maybe working with specific regions within the countries, specific sectors within or specific subsectors in the sectors that can help bring a more, let's say, a more favorable compliance environment and incentivize people to comply.
Well, thank you, Luis Felipe. Interestingly, as we observed on the largest agro show here in Ribeirão Preto in the state of Sao Paulo recently, as far as traceability is concerned, which is one of the main issues that Luis Felipe addressed, there are some very innovative solutions on the way, and some of them already have been introduced to the market, and some of them by startup companies here from Brazil, where products for the monitoring of the origin, for example, appear to be rather sophisticated and might even be an option for the European market. So when you're speaking about winners and losers in this, there might be unexpected winners too, being those startups. Maria Cristina, as refers to the European legislation and the consequences here, and having in mind the commentaries of Gabriel and Luis Felipe, would you like to add anything else?
Yeah, I think just that positive message, I guess, that Brazil is also looking to a lot of the issues that Europe is concerned and is legislating recently. And I think it's a matter of building a bridge, of cutting the distance, and working and making progress in order to align what are the expectations on both sides. But I think the sessions today were very clarifying, the presentations as well, because we got the opportunity to go into the rationale that's behind all such recent changes. And also we could hear that there are more changes to come, and we could go into detail of some aspects to understand how companies in Germany are also looking at this.
Yes, and interestingly, Brazilians and Germans don't appear to be too far away. If I listen to you now and remember what Rainer said initially about the objectives of all of this and the origin, giving context, I guess at least among all of us here, there's no second opinion as to sustainability being key to humans' future, and that it's mainly about details. And maybe there are some affected parties, certainly there are, here in Brazil also, who will perceive certain parts of the regulation as unfair, having in mind Industrial Revolution and the posterior development of developing countries, more specifically of Brazil. But that dialogue should be the means to resolving these differences, ideally not trade litigation, trade disputes, but we will see about that. What is still missing a little bit, and maybe we can use the last few minutes of our webinar to see if there are any comments, is also feedback from the audience. Would you like to discuss any issue? Would you like to give us your opinions and insights as to where your companies stand, whether you liked or disliked the webinar? Please go ahead.
Alex, I have one comment.
Sure.
I think this is obviously boring. This is a lot of paperwork the company have now started preparing. This will cost money. This is putting in the right words, a pain in the back. But I think we can look at it another way. We have, and this is not only Brazil, but Brazil specifically, but also other countries in Latin America, competitive advance there. Remember, the law is applicable all over the world for companies, for German companies, which are facing buying or doing businesses all over the world. And obviously, Latin America has a lot less issues than products coming from Africa or products coming from East Asia. So we have there really a big competitive advances. If you look for cocoa, for example, or for coffee, the production of these big products are technified in Latin America. You have some issues there, obviously, but small issues. You have child labor in Indonesia. You have problems in Africa, in Ghana, in Ivory Coast. So this is a competitive analysis that companies can use. So you have a marketing tool also to present your products in a better way if you implement. So it's not only really a lot of work for companies, but you can also really use it as a very good marketing tool to access German or European markets. And I think a lot of companies has already seen it also there, that for consumers and for everything, if you comply to those all rules, you will have an advance here in the market. And if you see that way is a kind of investment, then you put everything in place what you need to do. And I think these have to be kept in mind.
I think on that positive note, Orlando, we can actually close our webinar unless anyone else wants to make another contribution. I would like to thank all of you for participating. A big thanks to the audience for sticking with us for an extended period of time in your afternoon, mainly. And as I think André said, there will be room for future webinars because this is a work in progress, and companies together with us as lawyers are finding out what best practice might look like over the next couple of years. So please stay tuned, and we'll be back for more webinars in the future.
Thank you.
Thank you, Alex.
Thank you, everyone.
Thank you.
Thank you. Bye.